Chairman, the Vice Chair, members of the Economic Matters Committee. For the record, I'm Delegate Steve Johnson, here to present House Bill 993, Business Regulation, Professional Power Washers Registration. At this time in Maryland, the pressure washing and chemical washing go totally unregulated. Needing only a power washer and a truck to say you have a business, the problem with that is that there are no regulations that govern the industry. No liability insurance requirements, and they are not required to pay workers' comp insurance for employees. This could all be detrimental to the homeowners. Pressure washing today with high power pressure can cause serious damage to homeowners' property as well as bodily injury to a worker. Chemicals used in cleaning, if misused, can cause damage to property and landscaping. Examples of some damage are in your bill packet. I think you were sent some pictures. Currently, the only remedy for damages to someone's property is for a homeowner to spend even more money to take someone to court. We worked in the interim with the MHIC to see if pressure washing and chemical washing could be put under the MHIC umbrella. After several meetings and speaking with their attorneys, they feel that the industry did not meet the standards to be put under the home improvement commissions because they're really not building anything or home improvement. However, the board did suggest that we should possibly create a registry that would ensure the industry had license, which would be a fee of approximately $60 per year, have liability insurance, and pay workers' compensation for any employees. And you should see a letter in your packet from Department of Labor that verifies that. There would also be civil penalties for violations of the requirements. The Maryland Department of Labor already regulates more than 26 professions that do not fall under the MHIC system for licensing and regulations. This is really a consumer protection bill. You know, we want homeowners, that's one of the biggest investments you'll make in your life is your home. And we want to make sure that they have some protections when work is done that does not fall under the MHIC umbrella. And with that, I would ask for a favorable report on House Bill 993 and turn it over to my panel.
Hi, my name is Tina Hampton. I'm the owner of Elite Power Washing. So I'm here today to urge you to consider implementing regulations on power washing in our state. As the owner of Elite Power Washing, a company that has been providing power washing services to thousands of commercial and residential homes in Maryland since 2017, I have seen firsthand the damage that can be caused by improper power washing techniques. There are two types of power washing, soft washing and pressure washing. Soft washing utilizes biodegradable chemicals and detergents to clean surfaces, while pressure washing utilizes high-pressure water. Both methods can cause severe damage to a home if not properly done. Over the years, we have encountered many situations where homeowners and property managers have hired inexperienced power washing companies that have caused significant damage to their properties. This damage includes broken windows, stripped paint, leaking roofs, shingle damage, damaged siding, and even house fires if property protection is not provided. Damage that can leave homeowners left with thousands of dollars in repairs without anyone left accountable. Unfortunately, there are contractors who have no consequences for such damages. As with any other industry, we need to create accountability and standards for power washing to protect our consumers. Creating a power washing registry would ensure companies have insurance and provide our consumers with proper protection in the event of an accident or occurrence. As a responsible business owner, I support the implementation of power washing regulations. This will ensure that power washing is done safely and effectively, reducing the risk of property damage and personal injury. In conclusion, I urge you to consider implementing power washing regulations in Maryland. The power washing industry is quickly growing, and with proper regulations, we can protect both consumers and businesses. Thank you for your time.
Hi, my name is Henry Bachman. I own a company called PowerWashCompany.com. I've been in business for approximately 35 years. We've probably performed over $25 million in pressure washing services in Maryland. I'm here to also suggest this bill pass because there is a huge need for protection for homeowners and commercial properties in Maryland. I'm sure most of you in this room have power washers yourself at home, and I can almost guarantee you probably damage your own properties just by not using the proper techniques. Over the last 35 years, I've been involved in creating training programs for organizations I've probably taught probably 15 or 20,000 people across the country how to power wash properly, and also over in the United Kingdom. I've seen millions of dollars in damages every day and caused by power washing using high pressure techniques or using unsafe cleaning solutions. Some of the common products in our industry are sodium hypochlorite, which is bleach, and I've seen people mixing that and also using muriatic acid and stuff in conjunction with cleaning. Those two products alone will create mustard gas. And this is a pretty serious issue that we need to address. It's been going on for many years. I've been in front of MHIC about 10 years ago, urging licensing and regulation back then, and nothing has really changed. But someone needs to do something to protect homeowners from contractors who either don't know how to do it properly or just don't care. It's affecting our industry, and it's causing millions of dollars of damages every year this goes on. Thank you.
Sir, what was your name again?
Henry Bachman.
Seeing question, Delegate Aaron's.
Thank you, Mr. Chair. Two easy ones. We have a bunch of school kids that do this. They come around, they'll power wash their deck, they'll do these things. How does that affect them?
It would actually affect them. If they want to do power washing, if they damage the homeowner's property, then where does that leave the homeowner? I mean, I understand that you got school kids wanting to make some extra money. And if the homeowner wants to go ahead and let them do that as a neighbor, just like they do shoveling snow, just like they do babysitting, I'm sure that could be done. However, if there's damage, the homeowner's going to have to know that they're going to have to pay for the damage on their own.
Okay, the other question is, you have people that put on decks and patios and what have you, and they do power washing also. Would this cause them to have to go through more leaps and bounds?
Now, they're already licensed under the MHIC for the installation of the decks and stuff. But when they do power washing, if they build a new deck and put it on and then damaged it with power washing, again, the homeowner wouldn't be
If they're
covered.
if they're repairing a deck
They're repairing a deck,
and they power wash it and then fix it, you're saying
they already fall under the MHIC because they are installing something or under the home remodeling.
Okay, so then they don't need to do anything about a license or anything. They're protected.
They
based on
already
that
have
insurance.
liability insurance and
So
license.
you're just looking for somebody to get insurance to do power washing?
Correct.
Effectively.
That's correct.
Okay, thank you, Mr. Chair.
Delegate Fisher.
Thank you, Mr. Chairman. My question is there like an association, like
Several.
there is?
Yes.
And what's
Power
that called?
Washes of North America is one of them. I used to be a board director on it.
You were on the board of directors?
Yeah, I used to be on the board of directors for Power Washes of North America.
Do they have like courses that you can take there?
Yes, I actually developed, or helped develop most of the training classes that are in use today for best management practices for multiple organizations.
Which is great. I mean, and do you guys have like a certification when you take the course, you get some sort of stamp or something?
Yeah, we have online certifications, or there's written certifications for some organizations.
So, I mean, I ask because one of my arguments is that we shouldn't be licensing people to work in many situations. You shouldn't have to get a license to walk out your door and do something that really is purely laborious when you have an association that you can get a stamp from, and you can do your own marketing saying, I'm actually, I have the stamp of approval from my association. To me, that's much more valuable than the state. So why would this bill be necessary if you already have that and you were already on the board and you already wrote the regulations and you already have that stamp?
Honestly, because most people don't recognize the organizations because they're contractor run. In some cases, they're vendor created, to be able to sell products and stuff like that. But the problem is most people don't recognize how much damage can be done with a power washer. 3,000 PSI, you can easily cut through skin. You can damage concrete. I've seen concrete that's 15 years old get cut up by concrete. I've seen people remove graffiti and actually burn the image of what they're trying to remove into the side of a building. I've seen damage at Lincoln Memorial. We've done work there. I've seen Jefferson Memorial. There's damage there, all from other companies doing the work, or in a lot of cases, government places doing the work themselves. I've seen a lot of state and federal contracts going out requiring 3,000 PSI pressure to wash buildings. generally only need about 100 or 200 PSI and the proper cleaning solutions to do it.
I
So
just
every
asked
day,
because.
government employees are damaging buildings
No,
too.
that's a great answer. I just asked because when someone builds a deck, there are plenty of companies that build decks that do horrible jobs and they're licensed by the state. So that license really is meaningless. To me, the industry license, that's all I'm saying. It just seems like that is, because no one knows it better than you all.
Yeah.
Each industry being super unique in its own way, so. But
The
thank
one
you.
thing it will do is give homeowners protection, because most companies that are starting up power washing don't bother getting licensing or insurance or anything at all. They just throw something up on Facebook and, yeah, we'll power wash your house. And in some cases, when they're doing it, they'll set the house on fire.
Thank you.
I do feel like there's a misconception between, hey, I'm going to go pressure wash.
Ma'am, I'm sorry. There wasn't a question posed, so I appreciate you chiming in. There really wasn't a question posed. I believe the gentleman did give a very sufficient answer, and I just don't want to drag it on, especially if you guys are proving your point. So, seeing no other questions, I believe this is all for this hearing, so thank you guys very much.
Thank you, Mr.
Thank you
Chairman.
for your time.
Committee.
Next, we have Delegate Griffith.
Good afternoon. So my first bill was a big business regulation bill. Now I'm doing a study bill, and I'm a year away from doing a longitudinal data study for Fisher over here. So we're working our way that direction. For the record, my name is Delegate Mike Griffith, and I'm requesting a favorable report on HB 1162, the study and utilization of expedited licensing process for service members, veterans, and military spouses. And thank you, Chair Wilson and committee, for the opportunity to present. I feel we all want Maryland to be a safe haven for our military members, veterans, and their families. Additionally, Maryland's already made great strides in the area of empowering these individuals to be able to work in the civilian careers that align with their area of expertise. What this bill seeks to do is not only study how we can make sure more of our military members, veterans, and their families know what opportunities are available to them because of the work this body has already done, but how we can improve upon those opportunities. We ultimately want to find ways to improve upon this body's good work. Therefore, currently, Maryland law requires varying state agencies to help active duty military personnel, veterans, and their spouses obtain expedited occupational and professional licenses, registrations, and certificates in recognition of their military training and experience. It also requires occupational units throughout the state government to give credit to those service members for relevant military training, education, and experience in connection with any one specific license. For example, if a veteran served in the military as a nurse and wished to transition to the associated credentialing and experience to the same occupation in civilian life, not only will their initial license or certificate application be processed by the Board of Nursing, but be expedited within 15 business days after receiving all the required documentation for a completed application. But the board could also credit any training and education provided by the military and completed by the veteran towards any training or educational requirements for the license or certificate in civilian life. This obviously would significantly impact our nursing shortage for people that are nurses or corpsmen in the military to be able to move right into the nursing profession here in Maryland. However, even though these opportunities exist within the state of Maryland for service members, veterans, and their spouses, many are not aware of their existence and therefore do not take advantage of them. This is not only a missed opportunity for the state to gain highly experienced workers, but it's also a crucial avenue for service members, veterans, and their spouses to transition from service to civilian life. To this end, HB 1162 is a study conducted by the Department of Labor and Department of Veterans Affairs to examine several main questions. One, the number of service members, veterans, and military spouses that have used the expedited process and have had credit for military experience, education, or training applied to license requirements. Two, the type of experience, education, and training for which credit may be awarded for licensure, and whether or not the experience, education, or training is considered substantially equivalent to the requirements associated with the license they are seeking. Three, evaluation of sample application forms. Four, the examination of existing and potential outreach activities relating to the expedited licensing process. Five, the identification of best practices for disseminating the information regarding expedited applications for license. Six, the identification of ways to increase visibility on state websites for this information. And of course, the comparison of what Maryland is doing versus other states. And the requirement for this bill is the study would be completed by June 30th of '24. We have received what we feel is a friendly amendment for the Maryland Military Coalition to include in the study the timeframes for processing the expedited applications and where the applications are housed, located, and how interested parties can access them easily. The intent of 1162 is not only to ascertain how effective these programs are, but to gauge where we can make adjustments to better serve and provide for our military community and their families. Therefore, I request a favorable report on HB 1162. Thank you.
I believe you have two favorables, Jane Krenick and Bryson Popham, but they're both written, so never mind. It's just you. Apologies. Seeing no questions, concludes this bill hearing. Thank you very much.
Thank you, Mr. Chair.
I do believe we have somebody here from Delegate Atterbury's office. Is that correct? You can come on up. I know we plan on having somebody else do the bill, but he doesn't look like he's gonna make it in time.
Doesn't look like he will make it in time, so it's just me.
Yes, that's fine. So returning to House Bill 1136.
Can you hear me okay? Hi, I'm Liz. I'm also Chief of Staff for Chair Vanessa Atterbury. This is my 5th session working for her, and I've never testified for a bill before, so please be nice. And if you have any questions, please hesitate to ask them.
Could you briefly tell us your full name for the record, though?
My full name for the record is Elizabeth Twigg.
Thank you. You may
Great.
begin.
So thanks, Chair Wilson and Vice Chair Crosby, for having me today. HB 1136 is a study which requires the Office of Program Evaluations and Government Accountability, otherwise known as OPEG, to conduct a review of the effectiveness and efficiency of the state's workforce programs from 2018 to 2022. Just as an aside, Chair Atterbury wants to let you know that she's already been in conversations with OPEG about this study, and they indicated that they're already able and willing to conduct this review. I'll mention that the review would include a description of all the programs run by local workforce boards and the Department of Labor, the number of individuals receiving job training and/or job readiness services at each location, the number of individuals placed in permanent jobs maintaining employment for a year or more at each location, and it would determine that the workforce development programs and services of the state agencies and public authorities, what they offer, who they serve, and what their eligibility requirements are, and to determine finally whether there's overlap, duplication, gaps, and/or fragmentation among these programs and services. So in order to conduct this review, OPEG would be allowed to hire an independent consultant, the cost of which would all be covered by the Department of Labor. So thanks for your consideration for HB 1136.
Thank you very much. Seeing no further questions, that concludes this hearing. Thank you. Have a good day.
Thanks.
Thank you for coming in. Delegate Hartman, House Bill 1015.
Thank you, Mr. Chair and members of the committee. For the record, Delegate Wayne Hartman with House Bill 1015. So once again, a simple bill. This bill increases the period from the first 106 days to 120 days of employment, during which an employer would not be required to allow an employee to use earned sick and safe leave act. So you heard the bill before. It was early after the Sick and Safe Leave Act was passed. With more time lapsing, many people in the business community are still struggling with some of the effects of the legislation. So we don't believe it was the intent of the original legislation for seasonal employees to have this benefit. It creates true hardships for many of the businesses towards the end of the season. If you can imagine, some of the American college students are getting ready to go back, so they're leaving in August. They're getting ready to go back to their university. A lot of the workforce, the J-1 visa program, their universities are requiring them to get back. So when you have a seasonal employee after 106 days having the ability to take the sick and safe leave, it leaves a void in the ability to serve its customers. It's a hospitality nightmare. It is a true increase to small business. They're covering the cost of the employee who is not there, as well as, of course, the one has to fill in. And in all honesty, the 120 days that the bill suggests is still a compromise, but just trying to find common ground that the businesses and the, both sides of the argument can find agreement on. So with that, if there's any questions.
Seeing no questions. Okay, guess we'll move on. Thank you very much, Delegate. We do have Iona Stoka, David Rodwin, Terry Kavanaugh, Diane Jarek. Please introduce yourself and you may begin.
Good afternoon, Chair and members of the committee. My name is Ioana Stoica, and I'm a policy advocate with the Job Opportunities Task Force, a nonprofit organization that advocates for low-income workers, which is why we are in strong opposition to this bill, which would significantly impact workers' and ability to take care of themselves and their families. The way this bill is written right now, seasonal workers would never get sick leave. We've heard about the 120 days, but this would mean that the period between seasons would be 245 days. Shortening the time, this bill also shortens the time after which leave is reinstated from 37 to 32 weeks. So what this would mean is that returning workers don't even get the leave that they earned the prior year if they come back to their job the following year. So this bill is not just about workers not being able to take off at the end of the summer. It's also about them coming back and not having leave when they come back. It's been said in prior years, and then you might see this in written testimony, that the affected employees are teenagers or students. First of all, people of all ages get sick. Second, we know that today's young people face as much or as dire consequences as prior generations in almost every respect, from stagnant wages to affordable housing issues. Third, it is an incorrect assumption that all of these young people are just trying to make some extra cash. I was a teacher in DC public schools for a decade and a half before I took this job. And I can't tell you how many students I taught who were working part-time to support their families, to pay their electricity bills, or to buy clothing for their little brothers and sisters. The fact is, many students entering the workforce are legal adults, and they are learning to live and make it in the same world that we are in. So their age is not a valid reason for precluding them from benefits. But this bill is not just about students. The 120 days could be used by any employer, even those who hire year-round. And the provision about reinstating leave upon rehiring workers applies to all sorts of businesses. For example, in the case of our organization and our trainees, construction jobs, many of which are project-based. I'm out of time, but we urge an unfavorable report. Thank you.
Yeah, Mr. Chairman, members of the committee, Terry Kavanaugh with the SEIU State Council. We've submitted written testimony. I won't repeat that, but I just want to spend just a minute on where if you look at what's currently there, it's 106 days. That's a pretty odd number, or an even number, but an odd choice. The original proposal was 90 days, specifically and that's pretty common language for temporary workers. But in an attempt to work with all the sides involved, we looked at what was the greatest number of days between Memorial Day and Labor Day, and what could be the greatest number of days between those two dates, the traditional start and end of summer and summer employment. And that's where the 106 days comes in. That was the compromise. It was a painstaking process to work through that. We don't see that there's any change from that, and we don't see the merits in making a change. So we ask you to vote unfavorable on that bill. Thank you.
Good afternoon, Mr. Chair, members of the committee. My name is David Rodwin, and I lead the Public Justice Center's Workplace Justice Project. I agree with everything that's already been said in opposition to this bill, and I won't repeat it. I will say, just for some additional context, most states that have sick leave laws have 90-day probationary periods. Maryland's is sort of an outlier, adding time to that. 3 states that have sick leave laws don't have any probationary period, so you can use your sick leave as you earn it. In Maryland, you only earn 1 hour for every 30 hours you work, so it's not like you could take a ton of leave right at the outset. So we already have some compromises here meant to benefit the employer community. This is one of a great many compromises that were a part and intrinsic to this bill's passage. And I don't think now is the right time, especially with the pandemic being not even in our rearview mirror yet, to weaken sick leave protections in a way that would encourage workers to come to work while sick. So I'll leave it there, and we ask for an unfavorable report. Thank you.
Delegate Fisher.
Thank you, Mr. Chairman. Quick question. I presume that the sponsor of this bill is targeting it to the seasonal workers in Ocean City, I'm guessing. That's
Thank you.
about right.
Thank you, Delegate. The bill would apply statewide, so it's not limited in any way to Ocean City. It would apply to.
Okay, no, fair enough. Would you all be willing to compromise if it applied to just college students who work for that period of time in these seasonal jobs and then went back to college, at least for that 4-year period or so when they're in college? That an exemption for them? I mean,
I don't know if that's directed to all of us.
Anybody.
So the people are going back to college. I mean, I don't know, going back to college, they probably wouldn't be working beyond 106.
Not necessarily. I mean, they could be taking 1 course or 2 courses, living at home. And I think that's the sponsor's point of flexibility. I mean, they're also still in their parents' health insurance plan until they're 26. So, I mean, my question is, why not be more flexible with these seasonal workers?
Well, we were flexible when we moved from
Just not
90
now.
to 106.
No, I understand. I heard your testimony. You're not flexible now because it's one size fits all, which is not the way things really work in the real world. But notwithstanding that, do the Eastern Europeans who work in Ocean City at those facilities, are they subject to this law? When they're here, they're citizens of their countries in Eastern Europe, but does this law apply to them?
I would have to check on that, but I believe it applies to workers who are working in Maryland. These are standards that you've established for workers
Understood,
while they're
but how
working in
about if they're
Maryland.
here for only 4 months and they go back home to Eastern Europe, which more than likely they do, so the bill really doesn't apply to them. So my point is, you all being part of labor, is you're literally, through your inflexibility, in my opinion, it's my opinion, causing these companies in Ocean City and elsewhere, and especially in the seasonal businesses, to hire people from outside the country to try to be able to make things work for them. So why not just compromise, and that way you get people who are citizens of the United States working in these jobs instead?
I'm not sure that's been.
Oh, it's completely the case. I mean, if you've been
Well,
to Ocean City,
let me
everybody
ask
there
you.
is from Eastern
Let me
Europe.
make the point to answer
Come on.
your question. I don't think the sponsor of the bill made that point, so I'm not going to refute a point that was not made.
Seeing no further questions for this panel, you guys are excused. Kaylee Shumitz.
Thank you, Mr. Chair, members of the committee. Again, my name is Callie Shumitz with the Maryland Center on Economic Policy here in opposition to House Bill 1015. I think the prior speakers did an excellent job explaining the reasons that we are opposed to this. So I'll just echo their statements. We think this decision was made when the law was passed. That is working fine as it is, and this would affect not only seasonal workers in Ocean City, but as the prior speaker stated, this would affect all workers in Maryland. So we think it is harmful to our economy and to take away these benefits that folks have today. So we'd ask for an unfavorable report on House Bill 1015. Thank you.
Yes, ma'am. Well, I guess I do have a question. So would you oppose it just if it did focus solely on seasonal workers? Would you be okay with this bill?
I mean, our position is that seasonal workers get sick too and need sick leave. So, I think ideally, we think everyone should just have sick leave from the beginning. But again, this was a compromise that was worked out at the time. The 106 days, as Mr. Kavanaugh explained, reflects the general time period that summer seasonal work happens. And so we think that's a reasonable compromise. And there's no evidence that we've seen that it is harming businesses or the economy to maintain the status quo.
Thank you very much, ma'am.
Thank you.
Delegate Adams?
So where did that,
I apologize.
Sorry.
I'm sorry. Where did the 106 days come from? Because it sounds like you were part of the issue when we were bringing this bill forward and it passed.
Sure. As I'm not sure if you were in the room when the prior speaker was explaining it, but it was the longest period of time between Memorial Day, the longest possible number of days between Memorial Day and Labor Day.
But it was brought by the Ocean City senator who was trying to create a seasonal exemption. The 106 days is prescriptive, and it was the best attempt in the last waning hours to try to protect our seasonal workers. And the testimony is that those 106 days, while as a layman legislator from the Eastern Shore captures a specific set of days between two holidays, the point is that the real season is greater than 106, and I don't think the bill is doing anything other than just trying to meet the legislative intent that was maybe not met quite as well as it could have been as it was being negotiated in the 11th hour on Sine Die when the bill passed. So I'm only asking you through the lens of how did that 106 days come up, and it was from the senator from Ocean City. Is that not so?
That is my recollection.
All right, thank you.
See no further questions. Now you're excused, ma'am. Thank you very much.
Thank you, Chairman.
I believe that is all the oral testimony on this bill. So that concludes this bill hearing. Delegate Embry, House Bill 1055. Would you like Delegate Embry to come up with you?
We'd like to, of course.
I mean, you guys are both 1 and 2 on the bill,
you.
so.
And can we bring up an additional panel member?
Who else? You can bring your panel up as well.
Thank you. Great. Do you want to put your amendment or I was going to? Okay.
You guys may proceed.
Thank you, Chair Wilson. Thank you, members of the committee. This is my first time here. I'm excited to be here, and especially with Delegate Ampry. So this body has in past years passed historic criminal justice reform that requires accountability of law enforcement and transparency to the public, and I believe that this bill is consistent with that reform and extends those principles of accountability and transparency to the private security guard industry. Security guards, who are often armed with a firearm and other weapons, are placed every day in situations where they have to make decisions about whether to use force and what kind of force to use. There's currently no requirement in Maryland that a security guard receive any type of training beyond what is required if they have a wear-carry permit. This bill would require training both before certification by the state police and every 3 years. This is consistent with 28 other states, and the training would include appropriate use of force and de-escalation techniques. Additionally, the bill requires that employers of security guards have to submit a report of use of force to the Maryland State Police every time that it occurs. This will provide data on the frequency and the nature of the use of force and possibly provide guidance to this body for future action. In Baltimore City alone, 3 security guards have shot and killed people in the last 2 years. 2 have been charged with murder. The 3rd was determined by the state's attorney to be a justified shooting. The Baltimore Sun has written about security guard Keith Lucky, who shot and killed
Kevin Guerrero at a bar in the Highlandtown neighborhood of Baltimore City in November of last year. Mr. Lucky had a prior documented use of force, many issues, including pending assault charges when he killed Mr. Guerrero. He had also used a stun gun on a woman in a wheelchair while he was working as a security guard at a pharmacy, and he'd used physical restraint an additional time. Currently, there is no requirement that Maryland State Police, who certify and oversee security guards, are notified of use of force. So this bill would correct that. So they were unaware of Mr. Lucky's history. The bill also expands the coverage of the regulatory structure to all persons providing security guard services. Currently, the regulatory structure only applies to security guard agencies, and some representatives of those agencies are here to testify in support of this bill. Finally, the bill strengthens the certification requirements, including a requirement that in addition to not having convictions for crimes of violence, if the applicant has previously worked in law enforcement, that they have not had findings of excessive force or false statement in their past. I also want to mention I have distributed an amendment today based on conversations with co-sponsor Delegate Ampry that would disallow a guard from working while awaiting certification. So currently a guard, if they've applied, they can work until the state police makes a decision about certification. So that would be discontinued. They have to receive it first. And also in conversations with Maryland State Police, in conversations with the industry, there are a few technical amendments that I'd like to add. They're not drafted yet. That includes having a more specific timeline for the use of force reporting, also for requiring state police to create a use of force reporting form so there's consistency. So I will be providing additional amendments for your consideration within the next day or two. And so with that, I will turn it over to the co-sponsor, and I request a favorable report on HB 1055. Thank you for your time.
So I'll quickly add a me too to everything she said. But ultimately, I think this bill is really important given the fact of the new industry that we are about to embark upon here in Maryland, and understanding that we're probably going to see a large influx of security guards that will be utilized at these facilities. So it's important that we have a system and program that ensures that accountability is there for those individuals who are security guards, and ensure that these companies have regulations that keep not only the security guards safe, but ultimately keep the public safe. So with that, I urge a favorable report on House Bill 1055. Thank you.
Thank you. I have a question for either of you. So firstly, when we talk about crimes of violence, are we talking about second-degree assault?
I have used the crimes of violence definitions in public safety and 14, I'm sorry.
Because we know how Maryland, sometimes we define that as a crime of violence when it could be just a basic unwanted touching.
So I believe that is a disqualifying crime under 5101 of the public safety article, but not under 14101, which are both included. But I would be happy to for an amendment.
Because I do believe that it's sometimes difficult finding individuals already, especially with our ongoing marijuana issues, to even qualify for these jobs. And having an unwanted touching, and I understand that there's some consternation with this, but that's everything from a fight you had when you were 19 or 17 to, flicking somebody in the ear on a bus. And I guess that would be a concern. Additionally, are we talking about different standards for armed and unarmed, or is this purely addressing armed security guards?
This is addressing both. The difference would be that, of course, for an armed security guard, the Maryland State Police would confirm that they have a valid wear-carry permit, and that they would have to indicate that they intend to carry a weapon. But as you raised with the issue of previous convictions, while those would be disqualifying for carrying a weapon, this committee may want to have a slightly different standard for unarmed.
And I say that again because we have a hard time finding cops. Sounds like you're having a fairly high standard with rationale and reason behind it. And I kind of don't want to be stuck in that same issue again with security guards, because it sounds like you're raising a fairly high standard for security guards. And let's be honest, most of them would be cops if they were at this point. So just worried about creating another issue. And I'm not saying we do nothing. I just wanted to get your input on just what this, basically, compared to what a police officer background check is, how far are we going into a security guard? And it sounds like pretty far, correct?
Yes, this bill does, right, because security guards are using force against
Right.
civilians and people in all kinds of situations. So this bill errs on the side of caution, but I understand your concern.
Yeah, I mean, you understand, because, again,
I do.
I'm not saying that, it's just rolling through. And this require yearly training?
Every 3 years.
And maybe that's another way of addressing this, is in shortening the training or the amount of training or the type of training, because I'm just concerned about, having security guard firms not be able to find people that qualify in these I don't know, because we're already struggling with police officers.
Well, I will defer to the next speakers because they are representing the industry and have far more knowledge than I do. I will say, one of the things this bill does, as I said, is it not only covers security guard agencies, but also if, for instance, a Walmart employs a security guard. So it does broaden the universe that is covered by regulation. And so I think one question is, what impact will this have on not just the agencies who are represented here and can answer your questions, but the broader universe?
Sure thing. Thank you very much.
Thank you.
Mr. Chairman, John Pica on behalf of the National Association of Security Companies. And there's another panel, my client and two others are right behind me. I don't know that we're raising standards. Right now, there are hardly any standards. If you look
By definition, you'd be raising them, but go ahead.
Okay, well, that's a valid point. And thank you. However, most states, maybe as many as 40, and I'll get the number, require some kind of training.
Sure.
All Maryland requires is that the individual be of good moral character and reputation. So this would institute training requirements, both initially and renewed every, I believe it's 3 years. It has the amount of hours that are required, but there are some things in this bill that are important to note. For example, if you have less than 5 security agencies, security guards, you don't have to have insurance. If you have 5 or more, you have to carry $1 million of liability insurance. So if you have a small company and someone is injured and they sue, individuals that have no insurance. So this bill would have an insurance requirement of $500,000 for companies with less than 5. And I like to defer to the industry. They have some very technical, they have answers to any kind of technical questions that you have. So if I can just stay here when the other 3 individuals come up, if that's okay, Mr. Chairman.
It's kind of weird. I mean, you're deferring to them. Why don't we just let them come up?
That's what I suggested.
Yeah, but that doesn't mean you have to stay there.
I'll leave.
I'm just confused because I would like these gentlemen to come up. I'm sure
right here.
I'll text you if there's a question I have, buddy. I think you did great. Thank you.
Thank you, Mr. Chairman.
The next round of people, we have Kelly Donahoe. Wait. Questions for this? I apologize. Oh, shit. I apologize. All right, I'm sorry. I was so excited to get John out of here. I just kept going. Delegate Wyville, please go ahead.
Thank you, Mr. Chairman. I heard what you said about who's covered, but I was reading the fiscal note and I'm a little confused. Does this only apply to security guard companies or even, say, the warehouse or the retailer who hires a night watchman that only carries a cell phone?
It applies to anyone providing equivalent services. So it doesn't matter if they're employed by an agency or directly by a warehouse or other.
Okay, so if the warehouse has a guy driving around the perimeter with a cell phone on him, he's covered by this bill?
Well, if he meets the definition of providing security guard services. So driving around with a cell phone,
Well, in that
no.
scenario, do you consider that as providing security?
If he would be responsible for interacting and stopping someone from burglarizing, then yes. If he's protecting
I think
the
he's
property.
probably just calling the police.
If he's just calling the police, then I think that's questionable. I would ask for the state police's view. But if the definition is meant to apply regardless of who the employer is.
Okay, thank you.
Next, we have Delegate Frazier Hidalgo.
Thank you, Mr. Chair. Just a few quick questions. Number one, how many hours does this require of training?
12 hours initially, 8 hours every 3 years. If the person has been employed in law enforcement within the past 3 years, they would not have to go through the initial training.
Okay, and who would be providing the training? The Maryland State Police?
No, so the structure is that the Training and Standards Commission would pre-approve and post a list of training that met their criteria that was sufficient in their view. They've done a lot of work on use of force training so that the person applying for certification would be responsible for receiving that training and providing documentation that they'd received it.
And they would be paying for that certification?
If it was if it cost money.
Okay, so either the individual would pay for the certification or the security company, their employer would pay for the certification for themselves. Do you have any idea what that might cost?
I do not, but I'm sure that the next panel will.
Okay, thank you very much.
Thank you.
Thank you so much, Mr. Chair. Really quick, I just want to make sure I got the amendment that you guys are proposing right. Essentially, folks will be at a standstill as we review any prior force, right, as they go through that process, just to make sure there's no unintentional consequences, although I understand the rationale behind why we're doing this. How long will that really take, right? Will we have folks in waiting? I mean, will it expedite the process?
I actually think the next panel they really will know the precise amount of time. But yes, there will be some period of time when Maryland State Police is verifying that everything that has been, everything that's been asserted in the application and all the documentation is correct. But I will again let the next panel answer the precise amount of time. Thank you.
Thank you. Kelly Donahue, excuse me. Zenita Hurley? Oh, no, we'll wait for Zenita because she is virtual. Steve Amate, Dr. Keith Williams, Nicholas Peros. So if you please start by introducing yourself, and you can begin, ma'am, when you're ready.
Thank you, Mr. Chairman. Good afternoon, Mr. Chairman, Mr. Vice Chairman, ladies and gentlemen of the committee. My name is Kelly Donahue. I'm the legislative chair with the Maryland Association for Justice. Thank you for your time today. Thank you, Delegate Embry and Delegate Ampry, for your sponsorship of this bill. I ask you for a favorable vote on House Bill 1055. To answer one of the chairman's questions, 14-101 of the criminal law article does not include second-degree assault as a disqualifying act. Most of the crimes under 14-101 are rape, murder, first-degree assault, things of that nature. I suppose we were asked to testify on this bill because, all of our members, there's over 1,000 of us, we are all trial lawyers in the state of Maryland, and so when somebody is injured as a result of the negligent conduct of a security guard, you might imagine that one of us might be contacted. I can tell you just from boots on the ground experience, I have had folks contact me. One example comes to mind. A gentleman was leaving a bar. There was an escalating situation with a security guard. The security guard handled the situation by beating this individual in the head with a glass bottle and putting his face through a glass window. I think this bill is particularly important because security guards are charged with protecting the public and children, and they often carry weapons, and they confront situations like the one I just described. So it's important that they are trained and certified to be able to protect the public, protect themselves, and protect their employers. And this bill does exactly that. It requires training on de-escalation techniques. It requires training on how to deal with minors. It requires training on how to deal with persons who have behavioral illnesses and other impairments. So I'm happy to answer any questions, but I think the bill is just, frankly, very common sense. And if employers are already doing what they're supposed to do to comply with the standard of care, then this bill has no impact on them whatsoever, and they're good to go. And if they're not, then this bill puts some teeth into what needs to be done. Thank you very much for your time.
Ma'am, I do have a question. I paid my way through college, law school, by being a bouncer in nightclubs in D.C. Would this apply to nightclub security, bouncers, things of that nature?
Yes, I believe it does.
Oh, okay.
Mr. Chairman, I have full confidence in your bouncing skills, though.
Chairman Wilson, members of the committee, my name is Steve Amate, and I'm the Executive Director of the National Association of Security Companies, the nation's largest contract private security association. In the state of Maryland, NASCO companies employ over 7,000 licensed and trained security officers who are providing security services to a vast array of Maryland businesses, public and private organizations, healthcare facilities, schools, and other institutions. For decades, NASCO has worked with state legislators and regulators around the country to put in place effective laws and regulations for the licensing and training of security officers, and that's what brings me here today. NASCO is very supportive of the three underlying common sense public safety first premises of HB 1055. One, all employees providing security services anywhere in Maryland, whether through working for a contract security company or working directly for an establishment such as a bar or other business, should be required to be licensed and vetted by the state. Two, all employees providing security services in Maryland should be required to complete appropriate security services related training, including use of force and de-escalation training. Three, all employers of security officers should be required to have insurance to cover any harm or damages that may result from the actions of the security officers while they are working for that employer. There's no doubt that working as a private security officer is a very public-facing job that will necessitate all types of interactions with Maryland residents. Sometimes it's a friendly hello and an ID check at the entrance to an office building. Other times it can be a more tense interaction. Simply put then, if the goal is to put in place measures that can both decrease use of force incidents by security officers and create more transparency and accountability related to such incidents, then what better way to attain that goal than to require that all security officers in Maryland be licensed, vetted, trained, and insured? And there's no doubt that better vetted, better trained security officers translate into better performing security officers. There's still some language in the bill that we think needs some improvements, and NASCO looks forward to working with the bill sponsors in the committee to make those improvements and pass this common sense bill. Thank you.
For anyone on the, thank you, Mr. Chair. For anyone on the panel, do other states require bouncers to get this type of training and licensing?
Yes.
Okay.
Many do. In fact, Tennessee just instituted a law after some bouncers at Dirk Bentley's bar, beat up and killed a patron, and two of them were licensed, two weren't, and they said anybody who's doing security needs to be licensed, needs to have de-escalation training and use of force training.
And that was in response to that incident?
Yes, it was.
Okay. Any others besides Tennessee?
Oh, yes. Oh, there's many states, but I'm just saying that's the most recent example.
Can you get a list to my office, please?
Sure.
Thank you.
So was that security officer at the Dirk Bentley concert, or the one man, which was just your perspective on that one, was that security officer fired? Did he go to jail? Did he face criminal charges? I'm sure they did.
Yeah.
I would guess the answer is yes, correct?
Right. But
okay, so there's a mechanism in our justice system to make people whole and hold these people accountable, correct?
Well, but there's also ways to prevent someone from being, murdered at a bar.
And
because
if I read this bill correctly, while they're waiting for their background check or whatever's coming through, they can't work.
That is not the law.
That's not the law.
No, right now that once you've submitted,
That's not the law now, but
Right.
that's the law according to this bill.
and we're not supportive of that change.
All right, thank you, Mr. Chair.
Chair, thank you very much, committee. Thank you. My name is Dr. Keith Williams. I'm Vice President of Support Services for Admiral Security Services, which is a Maryland-based security agency. Prior to joining Admiral, I was a commander in the Metropolitan Police Department for 27 years, ran our training academy and risk management. I also handle training and quality assurance for Admiral Security at this time. We are here in support of this measure in part. Some of the changes that we'd like to have discussion with. But we believe that basic training is a positive force for security guards wherever they work. We also, as a part of our corporate culture, we have always had our onboarded security officers subjected to basic training in confrontation management, verbal skills, customer service, appearance, uniform and appearance, and laws and regulations. And we also believe that the reporting can have a positive impact by standardizing how agencies report this, and can also inform our training as we have ongoing training for the in-service. Thank you very much for your time today.
Thank you, Mr. Chairman, members of the committee. My name is Nick Paros. I am currently the Regional Vice President for Allied Universal. To give you a scope of our company, we're the largest in the world with 850,000 security professionals around the world. And in the tri-state area, I represent 5,000 security guards, 3,500 which are in the state of Maryland. So a significant investment here in Maryland. I am a Marylander, live in Bel Air. Prior to coming to the company, I retired as a major from the Maryland State Police. During my tenure there, I was a lieutenant in charge of licensing division for 3 years. So I did license security guards, private detectives, and issue handgun permits. So I'm prepared to answer any questions in that regard as well on what we did back then. Retired in 2006. We're here and generally in support of the bill. Currently, this would change nothing for companies like Allied Universal and Admiral, but it would do one thing. So right now, if there's rogue companies out there that provide no training and one of these bad incidents occurs, what happens is we all get lumped into security guards are terrible, security guards are mall cops. They're not. These are people that want professions, and we are providing a gateway to a really good job. My chief operating officer was a security guard at one time. I was a police cadet, and look at me today. So these jobs are good jobs, and these jobs can't be tainted. We want to train people. We do train people now, and we think that this is just good policy. I don't think anybody would believe if you asked them in your district if security officers had training. I don't think anybody believed that the answer would be no in the state of Maryland. And that's why this bill makes a lot of sense for Allied Universal.
But they do have training. I mean, there's no way I can believe that an unarmed security guard it doesn't have any training versus an armed security guard. You're telling me there are people on the streets right now providing security that have no training whatsoever,
Yes,
no
sir.
background check whatsoever.
Absolutely.
Insurance companies are insuring companies for millions of dollars, and they've set forth no standards for those companies as far as the wear, use, and carry of a firearm at a high-value target.
Okay. So firearms are different because they have to be
So there
licensed.
is a bifurcation between the two. There's an unarmed security position and an armed security position.
Yes.
The armed security position does have training. The unarmed security positions don't have training.
Well-
And they generally detect and report, and that is their sole functionary, correct?
Partially correct.
Okay.
So,
Well, and sometimes on a mild basis, they'll interact with the public.
correct. So on the armed side, it's the exact same training you would get if you wanted your concealed carry permit and no more. So on the security guard side, what their authority is as a security officer, that's not covered in your handgun courses. Only the wearing
They're
carry.
not armed.
Well, I'm saying on the armed side. On the unarmed side, there's absolutely zero training requirement at all to get in and work today. I could bring somebody into the office if we were that company. We don't. They could sign an application, forward it to the Maryland State Police, and I could put them to work that day without a single minute of
And
training.
under this bill, they wouldn't be able to work until they were approved by the state police, even though we've had police officers have bad actions, and they're still able to work while under investigation.
So-
Thank you very much.
I believe that concludes these questions/statements for these witnesses. So, thank you guys very much. And
Sure.
it
Thank
was,
you.
Thanks, sir.
Appreciate, we do have, you call it Steve Amate? Steve?
I'm Steve, yeah.
Apologize, didn't strike your name.
All right, so I'm good. Thank you.
We have, one more virtual, Zanita Hurley. The OAG.
Hi, yes, good afternoon. Mr. Chair, members of the committee, on behalf of the Office of the Attorney General, we urge a favorable report for House Bill 1055. You've heard from the experts, and I know I'm one of the last witnesses to appear in support of this bill, but just on behalf of the Attorney General, we wanted to say we all know that security guards are being increasingly used to complement the work of police officers to ensure the safety of our communities, but they have much less regulation than the police. We've also seen the very real harm that security guards can exact when they use force to protect stores, bars, other community spaces that they're hired to safeguard. House Bill 1055 seeks to address this oversight by applying what we believe are common sense constraints on those who are certified by the state to provide security guard services. As I said in my written testimony, currently at least 23 states require security guards to be trained before they are licensed. And we believe that establishing minimum age training standards, prohibitions on certain criminal convictions, and use of force requirements for Maryland security guard industry is good policy. And it's also consistent with other reforms that the General Assembly has enacted to improve police practices and outcomes. And so for all of these reasons, we urge a favorable report. Thank you, Mr. Chair and members of the committee.
Zanita, I do have a question. You heard one of the prior attorneys say that they felt that second-degree assault would not preclude an individual from, I guess, being a bouncer in this state. Is that your understanding as well?
I actually don't know the answer to that question, but I'm certainly willing to take it back and look closely at the statute and get you an advice letter on that.
And to be clear, it is the Office of the Attorney General's standing that from security guard, night watchman to bouncer in a nightclub or a bar should go through these same standards. That's the Attorney General's view on this bill.
Absolutely, yes.
Thank you very much.
Mr. Chair, I would like to call on my panel. Thank you, Mr. Chair, and members of the Economic Matters Committee. For the record, I'm Delegate Lily Chi here to present HB 988, which is the implementation bill of the family and medical leave legislation that we passed last year. This year marks the 30th anniversary of the Federal Family and Medical Leave Act, which makes today's hearing extra meaningful and special. To be able to even introduce this implementation bill is a milestone that we cannot take for granted. For the benefit of the freshmen among our mix, last year we passed the Time to Care Act, which is the Maryland version of the Family and Medical Leave Act. It's also called the Paid Family Leave Act with the acronym FAMILY. The purpose of the family legislation is really twofold. One is to bring equity to those working for small organizations or employers who wouldn't otherwise qualify under the federal FMLA program, which offers 12 weeks of leave if necessary. And that is majority of the businesses, organizations in Maryland, about half of the Maryland workers. And the second is to provide a partial wage recovery for anyone who needs to take time off to care for themselves or family members in the event of a newborn or a child entering the family for whatever reason, and serious illness or other events that require their time away from their jobs. The family program that we passed last year is essentially an insurance program where employers and employees both will pay into the insurance fund, which will be used to recover partial wage loss for employees. Passing the Time to Care Act last year was a historic milestone and a heavy lift after over a decade of hard work and advocacy by countless people both inside and outside of this legislature, including our own Delegate Chris Valderrama of ECM. Thank you very much for your leadership. Our Chair Wilson, who brilliantly defended the bill on the House floor, and the great work of the staff and the committee members. But in order to create a fully functioning family program, the state needs to answer many questions and to better define, clarify, and codify the policy decisions we made last year. This is where HB 988 comes in, so we can start the implementation work in earnest and answering questions like a rate setting, cost share, employer notification, and the state's responsibility in cost share. So let me quickly walk you through the modifications we made this year. And I trust you have all received several amendments in your package that would clarify some of the details. First, the bill gives the Department of Labor more time, approximately an extra year, to implement the program. Because there's significant work to be done to build a brand-new program from scratch, an insurance program no less, from technology acquisition to staffing, as you can imagine, to outreach and regulatory drafting. So HB 988 essentially pushes back the implementation deadline. So the Secretary of Labor now has until October 1st of 2024 instead of this year to set the contribution rate and to start collecting contributions from both the employers and the employees. And also, the claim submission date would be starting January 1st of 2026, 2 years down the road after the rate setting. And also, the bill adds clarifying definitions of what counts as wages. And there are several definitions of that in the new amendment. And what counts as a family member, which now includes domestic partners, which is in line with most other states who have adopted a paid family leave program. Also about the leave itself, this bill clarifies when an event qualifies for both the federal FMLA and the paid family leave. That if it qualifies for both, they must run concurrently. It also clarifies that an employee may not be required to exhaust employer-paid leave, such as vacation leave or sick leave or other paid time off, before tapping into the paid family leave program, which is a difference from last year. And employer and employee can agree, however, to use the paid vacation and sick leave so that the employee can recover 100% of the pay. And an employer can require an employee to use certain other types of company-provided leave, such as parental care, family care, or military leave, or under a disability policy concurrently. And finally, an employee may apply for foreseeable leave in advance if it's foreseeable. And it also sets a deadline for application if it's unforeseeable. And the next point is the cost share, which is much talked about. This bill, HB 988, sets the cost share between employer and employee at a 50-50 split. It also allows the employer to pay for the full amount or a portion beyond that if they so choose. This bill also mandates the state of Maryland to pay the following parties their cost share. One is those community service providers that are certified by the Developmental Disabilities Administration, DDA, the Behavioral Health Administration, and the Medicaid community. So those are the community-based service providers. Also, the employer contribution portion for those employers with fewer than 15 employees. And finally, the employee contribution if you make below $15 an hour. However, if we pass Governor Moore's bill, which is the Fair Wages Act that he presented before this committee, then this clause would not be applicable because everybody would be making more than $15 an hour by then. And finally is the notification provision. Employers must be notified within 3 business days after an employee files a completed application for benefits instead of 5 days in the previous year's bill. And employees have a duty to inform their employers 30 days beforehand if it's a foreseeable event or as soon as practicable. I'm still learning English, as you can tell. These are the key modifications, along with some other administrative requirements, such as the reporting requirements for the Department of Labor, including annual reporting and annual cost analysis instead of every other year, and also data disaggregation so we can look at different zip codes, race, gender, and all of those demographic information. This bill is the product of collaboration with advocacy community, national experts, and the representatives from the insurance industry. I'm very proud that this modification bill has the broad support of many communities and different groups, including the Maryland Military Coalition, which represents 19 organizations that serve our military families. I did watch the Senate hearing, and I also read through all of the testimonies, including the unfavorables. I understand the business community has come around a great deal on this, and I truly appreciate their strong advocacy and their great work with us. Some, however, still have some concerns on a couple of different provisions, which I hope we can work out. However, I want to say that some of their concerns articulated in the testimonies have been addressed by the amendments, including pushing back the timeline. Finally, I want to say that as an immigrant who struggled mightily to find my footing in this country for the first decade and a half of my life, I wish we had programs like this when I needed them, both as a young mother with a newborn and when I had to take time off to take care of my dying mom when she was in Shanghai. I did not have the benefit of that. Now I find myself acting like a delegate Valderrama. People couldn't tell us apart anyway, right? So, I think we can all be proud that Maryland is now turning a page, can finally not only say we passed the legislation, but we can start implementing with meaningful changes. This is a moment to celebrate, so thank you very much.
I'll start. Good afternoon, Chair Wilson, Vice Chair Crosby, and members of the Economic Matters Committee. For the record, Andrew Fulginiti, representing the Maryland Department of Labor. Thank you for the opportunity to allow me to testify today and talk about the work the department is doing to implement this legislation. Through our initial completion of the studies and reports, conversations with stakeholders, it's become quite apparent that timelines needed to be adjusted to ensure successful implementation of the law. The department has spent a considerable amount of time analyzing other state paid leave programs, including their implementation schedules. Typically, other states have had a year between posting contributions and collection, and on average another 12 months before commencing their benefit payments. We have provided amendments to the committee for the legislature's consideration. As the sponsor noted, they generally push timelines back about a year. That would give us adequate time and flexibility, we believe, to set the contributions, develop the necessary regulations, hire staff, and procure necessary IT infrastructure to begin that process. With that said, I do just want to emphasize that the department will need additional personnel and funds in the future in order to effectively stand up this program and complete the tasks needed for a successful implementation. We're talking about the acceptance and processing of claims, contributions, and the payment of those claims. I do want to assure the committee that we are committed to providing this important benefit to all Marylanders and ensuring that we stand up a program that works for both employers and employees. And with that, we're asking for a favorable report by the committee with the suggested amendments. Thank you.
Good afternoon. Philemon Konjursky here today on behalf of the League of Life and Health Insurers of Maryland and the American Council of Life Insurers in favor of HB 988. The bill you see before you today comes from a tremendous amount of work over the interim in this session, and I'd like to thank Delegate Chief for introducing this important legislation. Life insurers offer paid family and medical leave plans across the country, and we believe they're vital to the health of the workforce and the financial security of families. We believe this bill is an important next step in ensuring that Marylanders have access to these benefits. The technical fixes in this bill, like I said, represent input from experts from across the country and reflect important lessons learned from programs similar to the one that will be built in Maryland. League members are supportive of the technical tweaks in this bill. We're also supportive of the sponsor amendments, and we believe the amended date suggested by the Department of Labor will provide the time necessary to implement the program. I'd like to reiterate the work on this program does not end with the passage of this bill. Life insurers have been proud to be supportive of Maryland paid family medical leave law since 2018, and we're committed to continuing to work with the state and other stakeholders to develop regulations in the coming months. Our life member experts bring with them a wealth of knowledge of these programs, and we will share that knowledge with state leaders in the year to come. Available virtually is one of these experts, Sarah Coley from Shelter Point Life, and she'll be able to answer any technical insurance questions you might have and provide additional insight of lessons learned from across the country. Thank you for your time today. I urge a favorable report of HB 988.
Mr. Chair and members of the committee, I'm Regan Vaughn. I'm a member of the Time to Care Steering Committee, and we represent over 2,000 members who have been committed to establishing a paid family and medical leave program in Maryland for the past 5 years. First, I really want to thank this committee. We've done a lot of hard work over the past couple years to pass the Time to Care Act. And it really was a monumental bill that made ripples not only in Maryland, but across the country as other states started calling us to ask what we had done and are looking at our bill as a model for other states. So I do want to thank this committee for that work. However, last year when we left session, we knew there were a couple unanswered questions. So after we had a quick celebration, we got down to work again. And I think it's really notable, the faces you see at this table now, because we weren't all sitting here together in previous years. But we really came together recently with the Department of Labor, with the insurers, to try to put together a bill that's going to make it so we can implement the Time to Care Act that you passed last year. We took numerous meetings over the summer. Anyone who asked to meet with us, we met with, whether it was schools, local government, employment attorneys, the insurance industry, our national partners, other states called to say, hey, before you get started, you need to think about X, Y, and Z. We ran into trouble here. And so we took all of that information, and I probably could have had a 500-page bill for you, and tried to distill it down to one, what isn't relitigating what we did last year. We aren't trying to recreate the wheel here. Two, is it going to help us with implementation? This is an implementation bill. And three, is it good for workers? That was another threshold question we have. And after we answered those three questions, we put together the bill that you have before you. Most importantly, it extends the timeline. I want to say we do accept the Secretary's amendments on that. And I've run out of time, and I'm happy to take any questions on the specifics of the bill that you may have and urge a favorable. Thank you.
Thank you, Vice Chair Crosby, members of the committee. Again, my name is Callie Shumitz with the Maryland Center on Economic Policy, and we thank the committee for this its work on this bill last year. We're here in support of House Bill 988 because implementing the program is very important to the success, and for all the same reasons that we supported the enacting time to care legislation last year. So in short, we all benefit when people can take time off to care for their family or their health without losing their livelihood. Families and children will benefit from greater economic security, improved health, and greater bonding time with new children. The program will particularly benefit women, Black and Hispanic Marylanders, and people in low-paying jobs who today often can't afford to take leave when they need it. Businesses will benefit from reduced turnover and greater ability to recruit and retain employees, particularly for small businesses that currently can't afford to offer paid leave to their employees. And our state's economy will see the long-term benefits of both creating greater economic security for Maryland families and making Maryland a more attractive place to live and work. So all of that is why we strongly support the 50-50 employer-employee split that is included in this bill. We think it's important that as Marylanders and working Marylanders and businesses alike share in the cost of the public insurance program as they also share in the benefits. The benefit of a statewide public insurance program is that nearly all workers and businesses in the state pay into it, and that keeps the costs modest for everyone. This split will also ensure that our paid family and medical leave program is aligned with the recently enacted programs in other states, including our immediate neighbors in Delaware and DC. So we, for these reasons, ask for a favorable report on House Bill 988. Thank you.
Thank you all. Delegate Valderrama.
Thank you, Mr. Vice Chair, and thank you to this panel. It is good to see all of you at the table together. As was said, that was never seen hardly ever before, and I want to thank my fellow sister here from the AP caucus moving forward on this, and it's okay to be like me. It just shows you're passionate. Regan, I just wanted to ask you, could you kindly share with us what you wanted to mention in your testimony? Because of the specifics, I know a lot of people here aren't as familiar with what we went through the last decade. So if you could highlight for me as well.
Sure, and I think Delegate Chi did a great job of it. I'll just add a few. First, extending the timeline is key. We want to make sure this program works, and it's worth pushing it off to do that. As Callie mentioned, the split in the bill is 50-50. Last year, that was left a bit of an open question, and so we want to have some predictability, and so everyone knows going in, it is in statute 50-50. We also changed it so the secretary will set the contribution rate on a yearly basis instead of a biannual basis. And that's really what a lot of the other states called to tell us we needed to do, and pointed out that we need that flexibility to react quickly if something changes in the economy. If there's a pandemic again, if there's recession, whatever it is, that contribution rate could go up or down quickly so we don't lose solvency of the program. We also wanted to make sure we could clarify what you have to do to apply and what you have to do to appeal. Some of those nuts and bolts questions that really should be in the statute and then can later be developed in regulations with more clarity. And then one of the big lessons we got from Washington, D.C. was they didn't know why their program was being underutilized until they did a disaggregated study on who was using the program, who was applying, and where there were denials. And they found that it was the same neighborhoods that were getting all of the denials in their program. And then we're able to dig down even further and realized it was an access to IT and broadband issue, that there were neighborhoods that couldn't download the medical certification, get their doctor to sign it, upload it, and submit it. And it wasn't until they had that disaggregated data that they could do better outreach. And so we did put in a requirement for the department to do a report each year so we can look at that data. And then also, we wanted to put more specificity into covering the contributions for the Medicaid providers. It was intent language in last year's bill, and we want to make sure that's clear in the bill. So those were big highlights that we added in.
If it was mentioned, I apologize. I'm glad you kept the 50-50. Was there a modification on the number of employees? There was that discussion if it was like a certain number of employees, 15 or less. Was there any change on that? Or
we kept last year's number of 15. If there's fewer than 15 employees, the employer does not have to make an employer contribution.
Thank you. Thank you, Mr. Vice Chair.
Delegate Queen.
Thank you, Mr. Chairman, and I want to thank you guys for bringing this up and making these modifications. So for the sponsor, you seem to have a lot of favorable recommendations, some with amendments, but the key concerns that I want to just make sure, and I may have missed it, are we addressing or have you addressed is from the Maryland Chamber of Commerce, the Maryland Chamber. That talks to the notification periods being very long and this concern about in the worst case scenario, somebody could be away for their job more than the initial 12 weeks of leave. Have you looked at that, or are we trying to address that? Can you provide some insight on that at all? If you have, if not, we can do it later.
Yeah, thank you, Delegate, for the question. First of all, I think this is an extremely rare circumstance that this could possibly happen. And secondly, as I mentioned in my remarks, we're happy to discuss further on these modifications to see how it might impact small businesses.
Thank you very much, Mr. Chair. So, to the businesses that have said for many years, mandate after painstaking mandate coming from this committee, enough's enough, what is the recommendation for those businesses that can't afford this 50-50 split?
Well, the 50-50 split First of all, this is not a new, this year's program is simply implementation and modification, right? So the program is already in place. So there's some baseline understanding that businesses will make some contributions, okay? So the 50-50 split is really based on some existing similar types of insurance programs, such as Medicare and Social Security, which the employer and the employee both contribute to 50-50, and then they draw upon that. So this is not a brand-new concept, so to speak.
Well, that doesn't answer, all right, so would a proposal be, okay, I can't afford to do it, so the employee will pay the half, and then I'll reduce their pay by that other half, whatever that amount equals, we'll reduce their wages to pay for that. Do you believe that's a possible outcome or a solution for a business that's concluded this is just enough, we've had enough?
Well, if you argue on that front, then I would say even if we mandated a net 10% the contribution, there could still be people who say we cannot afford it, you know? So
Fair enough.
I see your point, but
Well, I think it's what's, all right, so, and thank you for that. The other question I have is a technical question. Who pays for workers' compensation, and is that split? That might be a technical question that there's no answer for right now, because
I believe the employer does.
the employer pays 100% of workers' comp. All right, how about unemployment insurance?
The employer does.
The employer does, okay. And how about payroll taxes? Is that all employer as well? All right, so I mean, when you're a business that's trying to operate and you're trying to do so with some respect for the bottom line, I mean, I think it's not unreasonable for an employer to say, we've reached a point. I've been in committee for 9 years now. I've seen a lot of mandates come through, minimum wage, sick and safe leave. I've seen this bill, which I think stacks leave on top of plenty of different kinds of leave. I think businesses are going to respond at some point. I think they have to. I think there has to be some general acknowledgement. I think last year when we were silent on the percentage split, I think it was a general, it was respect for the principle that the businesses have probably reached a point and that we need to consider that when we bring legislation. Isn't that so?
All right, Delegate Aaron's.
Just, if you could help me, refresh me on, you said under 15 employees, the employer doesn't pay that part. Who pays that?
The state does.
The state pays that. So even if I'm a small business, state's going to take care of my business that way. Okay, who's the entity that's going to do the insurance? Did we settle that?
The Department of Labor? Is
They're
that
going
the
to, like,
question?
are they going to be the Aflac of this deal, or?
Yes, they are the administrator of this family insurance program and the fund.
Okay, who's going to actually do the insurance? You're saying the Department of Labor is going to be an insurance company.
Yeah.
Yeah, I mean, I can
We
speak to
have a
that.
labor representative, so.
Sure. So, I mean, that's something the Secretary Wu and this administration is taking a close look at. DLS just produced a report from the Spring Group that kind of takes a much more in-depth look at that, and it basically presents 3 pathways, if you will, that the state can take. One is a complete outsourced approach, which would be using like an Aflac. I think Connecticut might be the only state that uses a similar model. They look at an in-sourced approach, which is building it completely from the ground up, using the Department of Labor as the entity, similar to an unemployment insurance. Or there's a co-source model, which is using some sort of hybrid approach where certain functions are outsourced to vendors, certain functions are retained inside, and the report goes into depth about what the pros and cons of both of those are. The department has not made a decision, but the Secretary has committed to remaining open to those approaches, but we're taking a hard look at that right now.
I guess my only comment would be, with all due respect, is that the state's tried to be an insurance provider of some sort before, and I don't know that we've done such a great job in that. And I would think it would behoove us to at least have the path forward. And I don't really approve of carving out a niche for an Aflac or another insurance company to sit back and say, the state's going to fund all that. We do enough of that. I would like to see what we're going to do with that before any more legislation would be piled on, or if you could come up with an answer. Wouldn't that have to be defined before we did put this into effect? That's my question.
Well, I think the timelines we have built in would give the department the time to engage the third party if they so choose.
Okay, thank you. Thank you, Mr. Chair.
All right, seeing no further questions, that concludes this panel. I have one more favorable in person. It's Laura Wheeldryer.
Thank you. Good afternoon, Mr. Chair and committee members. I'm Laura Wheeldryer, Executive Director for Maryland Family Network, a statewide early childhood advocacy organization, and I'm here to express strong support for House Bill 988. We've just heard a lot of technical information about this bill, and that is very important to getting implementation right. But I'm hoping to use my 2 minutes today to remind us all why we are actually here. MFN's entry point to paid family leave was babies, new moms, new dads, birth, adoption, foster care. However a baby arrives, parents and babies need time. There is a mountain of public health research that shows the long-term benefits of parental leave for all. But we quickly learned that all kinds of people need access to paid leave. In fact, as the coalition talked to people around our great state, there is literally no one who can't imagine not needing paid leave at some point in their lives. As Delegate Valderrama so eloquently says, no matter our position or station in life, rain will fall on all of our heads. So a family dealing with a chronic medical condition that disrupts their lives, a military family preparing for a deployment or welcoming home a loved one, a spouse caring for his wife who's undergoing intensive treatment, a child taking care of her parent during the end stages of his life, a parent of a child with a disability who needs medical attention and time to heal. This bill is about real people and real life that often takes unexpected twists and turns. No one should have to choose between the job they need and the family that they love. Thank you for your leadership on behalf of Marylanders across the state who will benefit from this legislation. You are securing a healthier start in life for our youngest citizens and a more secure future for all. Thank you.
Thank you, ma'am. Seeing no questions, that concludes this panel. Next, we will go to the in-person favorable with amendments. I have Lori Doyle, Dana Kaufman, Laura Howe, Bill George, and John Wolms. Go ahead and start when ready.
Thank you, Mr. Chairman. Lori Doyle on behalf of the Community Behavioral Health Association of Maryland. We represent 110 organizations that provide mental health and substance use disorder treatment and support services in the community. We thank the General Assembly for including provisions in the original bill to cover the employer contributions for both developmental disabilities and behavioral health providers, since our rates are set by state Medicaid. And our written testimony includes the amendment language to that effect for both entities. But it should be noted that the major cost of complying with this program is paying for attempts to fill vacancies or the associated loss of reimbursable services due to staff vacancies. Our staffing ratios are set by regulation. So we're concerned about the new language on page 16, lines 19 to 23. The original bill required employees to use their employer-provided leave before taking this new insurance leave. But the new language says just the opposite, that employers are prohibited from requiring employees to exhaust their employer-provided leave first. That could result in employees taking 3 to 6 months off using this insurance leave and then taking additional time off for vacations or reasons not covered by this bill. We believe this penalizes those employers who have historically offered generous benefits and may cause them to reduce their employer-provided leave. Our written testimony offers a second amendment to change the language of this bill back to the original posture of the Time to Care Act. Thank you.
Good afternoon to the chair, members of the committee. My name is Bill George with the Maryland Municipal League, here today in support of House Bill 988 with 2 amendments. As many of you know, the Maryland Municipal League represents 157 cities and towns around the state. And while you may know us mostly for the quality of life services that our members provide, municipal governments also employ almost 9,000 people in the state. However, municipal governments are fundamentally different as employers from those in the private sector, for instance. The first is that the state mandates that municipal governments operate on a fiscal year budget that starts in July 1st and ends June 30th. And as you all know, operating a government on a fixed budget makes mid-year stream changes somewhat difficult. Oftentimes, the public sector can't compete with the private sector in terms of salary, but what we can do is offer phenomenal benefits, including a strong employer-sponsored leave program. This leads to a very high retention rate of employees in municipal government. So focusing on our two amendments, we thank the Department of Labor for coming forward with their proposed amendments, and we echo their desire to push the implementation date for the mandated contributions back because our members are right in the middle of their preparations for their fiscal year 24 budgets. So pushing the implementation date back to the October of 24 will give our members another budget cycle to figure out how much their contributions will be as an employer, but also whether their plan will meet the equivalency standard that will allow them to be exempt from contributions. And that leads me to our second amendment, and I'll touch on it briefly, as I know our partners with the Maryland Board of Education will touch on as well. But we need some clarification from the Department of Labor in particular on what the standards are to meet the equivalency exemption, and also the process by which our members can apply for that, because we feel that a lot of our members will exceed the state program and therefore want to take advantage of that exemption. Thank you.
Mr. Vice Chairman, members of the committee, John Willems, representing the Maryland Association of Boards of Education, here today testifying in strong support of House Bill 988 as proposed to be amended by the department. I want to thank the sponsor for the bill in the first place, as recognizing the need for a vehicle to amend the law as enacted, and then as we were certainly recognizing as boards of education the time it would take to understand modifications to employee benefits programs. Certainly if the Maryland Association of Boards of Education that already provides insurance coverage and workers' comp coverage to 18 of the 24 systems were to pursue developing a program on parity with the state, the time and conditions for doing so, understanding what the criteria would be, the procedures, the application process and timeline, the need for clarification, revisions, and potentially appeals from denials of the acceptance of that application. And so we greatly appreciate the extensions in the department's amendments, including the requirement that for regulations by January 1 of 2024. Our request would be just a little more granular clarity that those regulations do include that application review, approval or denial and appeals process for employer qualifying plans for the waiver or exemption from the employer and employee contributions under the law. And for those reasons, urge a favorable report on the bill as proposed to be amended by the department, with a respectful request for consideration of an amendment that I think MACO and MML and MAE believe would reflect our interest in standing up local programs that do, in fact, meet the high standards established under the law, or at least certainly striving in good faith to do so. Thank you.
Okay, I don't see Ms. Kaufman or Howe, so we'll go with Delegate Aarons.
Thank you, Mr. Chair. Mr. George, I got a question for you. Representing the Eastern Shore as I do, the many small municipalities and towns and whatever over there, and I look at this bill and some of the effects it has on not only local government, but on business development. Every one of us, we don't have the benefit over there of big corporations. We're all small business. Most of our business is that way. I'm wondering, how is this economically good for our districts? Tell me how it fits.
That's a tough question for me to answer, sir. I'm focused on our member municipality as they operate as local governments. And I can tell you that of our 157 members, about half will be exempt from their contributions simply because they don't meet the number of employee threshold.
So the taxpayer is going to bear that, right? Because half of them don't meet the number, so the government's going to pay theirs, so the taxpayer is going to pay that. How is this helping my small communities? I don't understand this bill. I don't understand it. Your positive testimony on this.
Sure. I mean, again, I'm focusing on this from the perspective of the operations of the governments themselves, and not necessarily from the economic development of the region in which they reside.
Yeah, I appreciate that, but I think if I were MML right now, I'd be rethinking some of this, because I don't have the ability right now to raise taxes on anything other than my people, my neighborhoods, my people living there on a day-to-day basis. I'm struggling for businesses, I'm struggling for employees, and this is going to put more of a burden on any employer. So his desire to come in and participate in one of our small towns is going to be, if he's over 15, that's a problem. If he's under 15, that falls on the burden of the taxpayers again. I just think that's a little difficult to accept this, because most every other county doesn't want to see these types of things because they have no way of overcoming these costs other than raising taxes. But isn't that so? Thank you very much.
Understood.
All right. Delegate Adams for a question.
I'll try to avoid doing the isn't that so or whatever.
I asked a question.
So other states, and you may have brought this up, I had to walk out for just a minute, but other states have, that have this paid family medical leave, do opt-in, opt-out sort of programs. Is that your understanding?
Yes, I believe that the research has shown that other states with paid family leaves do allow for local governments to either opt in or opt out. Most do.
And they opt out of it?
Oh, in the states that offer a local government opt out, most of the local governments do opt out.
Okay, and that's because they already have like paid bank leave, and in other words, they have other negotiated leave that relates to it. And I guess unlike the private sector, I gave an example earlier, but the other thing I can do is raise prices to consumers. I think local governments live under some fairly strict environments where unless you're going to tax more or cut services, that you almost have to have these sort of opt-in, opt-outs in order for the local governments to be able to operate for their constituencies. Would you agree with that?
Sure. I mean, if there's a will of the committee to pursue an opt-out for local governments, we will certainly consider it and provide feedback.
Okay. And I guess the only other question I have for, and Mabe, your Board of Education, I assume this is the same sort of conversation. I mean, these are collectively bargained benefits that happen only ever so often, so you're basically renegotiating your contracts, probably not yearly, it's what's it happening every, let me ask the question, how often do you negotiate your collective bargaining agreements with teachers?
Delegate, it is typically yearly, with reopeners for change in law and other considerations. The blueprint has certainly had a major impact on negotiations with the requirement to develop career ladders. I would say we are looking to the benefits of programs like this, and again, this is not the legislation to establish the program. That was last year.
Yes.
This is the bill to kind of get it right, if you will. And again, we believe that the bill, as amended, gets even closer to that goal. And so for those reasons, we are supporting with amendments. But in terms of how disruptive an across-the-board mandate to adopt a new system would be to school systems, it would be significant, which is why we're seeking the time to kind of crosswalk the benefits we currently provide and have negotiated and have kind of accrued over years. And there are 24 versions, as you can imagine, of those benefits programs throughout the state, respective to the 24 local school systems. And so, which is also why we're taking kind of a statewide view at MABE of how to implement this new law.
Right. So in other words, you collectively bargain him once a year, but perhaps that's the reason why you don't have a problem with that issue. But I'm kind of getting at the thrust of if you're offering these benefits, that they're part of a plan, it's probably not easy to just roll these in as quickly as we'd probably like. So you're saying, what I'm hearing you say is that the bill acknowledges that because it's throwing out into the further future implementation. Is that your testimony on that?
Yes, Delegate. Our benefits directors are planners and I'll say detail-oriented individuals and professionals, and so they are at once itching to know the details of program changes that have to be considered and implemented, and also want the adequate time to do that because they recognize there are political and budgetary considerations for each of the local school systems to make in adapting to this new law. So we again, the bill as proposed to be amended certainly satisfies our issues and concerns.
All right, thank you for that.
Delegate Pippi.
Thank you, Mr. Chair. I guess this would be a question for MML. I mean, in my district, I guess most districts, we've got a lot of municipalities. We have a fiscal note in here that generally tells us what the cost to state taxpayers would be. Do we have an idea of what this bill would cost on local municipalities? Is that something you could address?
So generally, it's difficult at the moment because we're unclear of the exemption for equivalent plan standards and whether many of our members will meet that as they think they will, right? So if they are able to meet that equivalency standard, then the fiscal impact on them will be negligible because their benefits and leave program are already built into their budgets, and they won't have to contribute to the state fund. So I think that it's difficult to say at the moment where the impact on our membership generally because of the uncertainty around the equivalency exemption.
I mean, that's a little frightening. I mean, we don't know.
Correct.
Okay.
Right, and that's why we're asking for clarification on where those standards are, so that our folks can budget for them, if they need to amend their plans or contribute to the state.
And then here's a scenario. So let's say a municipality has like 16 municipal employees. Would that municipality be able to, let's say, dismiss 1 or 2 employees and then not have any liability at all, because then it would just fall on the state taxpayers? Is that fair to say?
As far as I know, the cutoff is at 15, so I'm not sure of the repercussions for dismissing an employee for that sole reason, whether there would be some sort of issue around that. But as far as I know, there's no graduated phase-in or anything. You're either paying into the system at 15 employees or you're not at 14.
Okay. All right. Thank you, Mr. Chairman.
Thank you. Seeing no further questions, that concludes this panel. Next, we will go to the unfavorable in person. I have Mike O'Halloran, Andrew Griffin, and just you two. So start when ready.
2 is all you need, Mr. Vice Chairman.
That's it.
Good afternoon, members of the House Economic Matters Committee. For the record, my name is Mike O'Halloran here today on behalf of NFIB, and certainly I want to direct you towards my written comments. So my time here, I want to take drawing your attention to 2 of them. The first one revolves around the inclusion of the employer in this program, because the bill as drafted right now is really absent any employer notification. We can start with that. If you look at the bill, frankly, in every case, in every scenario, an employer is not notified until the department notifies them. So I would venture to offer to this committee that we change the program to involve the employer more by replicating what's done in Delaware. In Delaware, what they do is they allow the employer to be kind of the first line adjudicator, for lack of a better term. So the department would set out what constitutes a complete application, doctor's notes, all those things. An employer would then receive the claim from their employee, look at it, make sure that it fits the bill, approve it, deny it based on that, and then send it off to the employer. And the reason they do that is, number one, it allows the employer, obviously, to know that they have an employee that's availing themselves of this program. But number two, and perhaps most importantly, they can schedule accordingly, not just with the rest of their employees, but even with that employee that's availing themselves of the leave. Again, Delaware does this. Here in the state, employers are already required to administer the state's sick and safe leave program, so it's not like we're plowing more ground on that. And the last issue I want to bring up very quickly is the delay. Certainly appreciate the department's willingness to delay it more, but following our cousins in Delaware, I think it would be more advantageous to employee and employer both to move the contribution date back to January 1, 2025. So that way we're not beginning contributions, beginning a payroll tax in the last quarter of 2024. So 2025 for contributions, January 1, 2026, which I believe is already understood for the benefits. Thank you.
Mr. Chairman, members of the committee, Andrew Griffin on behalf of the Maryland Chamber of Commerce in very respectful opposition to the bill before you. I want to start by saying the bill sponsor, we appreciate her open door policy to the business community and trying to address some of our concerns. Most of the bill is technical fixes. There are 3 primary concerns we still have. The first does deal with notification requirements for unseen leave. The notification requirements are triggered at certain events. The stacking of those events totals potentially up to 110 days in which an employer, someone would be away from the workplace and a benefit determination would not be made. 110 days is longer than the first 12-week tranche of leave altogether. That may be good for the employee, as was heard when the bill was introduced, but that is certainly not tenable for a small business to be able to manage their workforce. The second component is the concurrence language. The concurrence language was changed to address taking employer-sponsored leave before this program. What this does is it says certain types of leave can run concurrent and others can't. For small businesses, many of them lump all of their leave in together to one pot. So there's no segregation of sick leave, paid time off. And so all of that leave that most small employers can really barely afford to offer would not be allowed to run concurrently. So I have suggested changes to address that issue in my testimony. And third is addressing the total contribution cap. In previous versions of this program, the last several years that have been introduced, there has been a cap on the total contribution that could be set in this new bill by the department at 1.5%. I think when you all last debated it, it was 1%. That's been since removed. This cost is being shared by employers, yes, and employees. I think it would be disingenuous from year 1 to year 2 to all of a sudden an employee says, hey, way more is being taken out of my paycheck this year than it was the previous year. So we would advocate for a cap on that. And with that, I will conclude. I think those things can be addressed, and we're happy to work with the committee to address those items. I'm happy to take any questions.
Delegate Charkoudian.
Thank you, Mr. Chair. I just want to clarify a couple things because we have last year's bill, we have this year's bill, we have amendments, and think I'm tracking all of them. But Mike, your point about notice, last year's bill has 30 days if it's foreseeable, I think. And then, of course, these are unforeseen circumstances, right? Somebody has an accident, so you can't have a notice requirement if a massive accident puts, someone that I'm caring for in the hospital and I need the time sort of immediately to care for them, right? So I was trying to understand what you were saying about notice, because I think we have notice to the extent that one can plan for what are sometimes emergencies. And I'm just wondering, but I don't think it's in this year's bill. It's in last year's bill. Did you want to clarify?
So what I'll draw your attention to is on page 6, beginning in line 17. Talks about the secretary establishing procedures for notifying an employer within changes to 3 business days after the following occurs. That's a lot of paperwork. That's a lot of filing for the Department of Labor, and certainly they are a very capable outfit, but they're not immune to running into difficulties. I think our suggestions provide a benefit not only for the employee, but for the employer as well, allowing that employer, as I mentioned, being that first line adjudicator. And please, I think it's equally important to ensure that should an employer errantly deny leave, that an employee can appeal that decision. I think that's very, very important. That's what we see in Delaware.
Yeah, I think it puts the employee in a difficult position if they feel like they have to then challenge the decision that was just made when they're already in a sort of vulnerable place in their life. But we can agree to disagree on that. Let me just ask a second question about your comment about 110 days. When we have periods of time where somebody is not being paid, I mean, they have it, the employee, assuming they need to be paid, has an incentive to get these things taken care of so they start getting paid. So there's not really an incentive for an employee to drag the process out if they're not being paid. So I'm just thinking, in my mind, and I guess I'm asking you to comment on this, there's the incentives are structured so that you have the timeliness, but if there are emergencies or urgencies or delays or things that are beyond people's control, they're not precluded from. I mean, that's kind of the balancing act that I see in what we have here. So I don't know if you want to comment on that.
Yeah, Delegate, I appreciate that, and I think I would agree with you, right? The practical scenario is probably in an unforeseen situation. Someone, emergency contact is contacting the employer and letting them know this is happening. Hey, we're going to be applying for these benefits when we're able to. That's probably what is most likely to happen, right? And that initial 60-day application timeframe, which is given, which then ultimately triggers that notice to the employer, we probably wouldn't hit that. But again, in worst case scenario, if someone doesn't apply for the benefit until the 60th day, which if they're an hourly employee, right, they're probably going to apply for the benefit soon. If they're a salary employee, maybe that doesn't necessarily hold true because the employer doesn't know what's happened to the employee. They may continue to pay them for a certain period of time, which you could run into other issues. And so I think the language we really would prefer would be the language mirrored from FMLA, which just says the individual has to apply for the benefit as soon as practicable. That leaves flexibility that, hey, if you can demonstrate that I was hospitalized, I couldn't apply for the benefit for 60 days, that is covered. But if you were discharged from the hospital after 5 days in your home and maybe 5 days later you're able to do it, sure, you're well below that 60 days, but the notice is coming to the employer from that triggering event of the application for unforeseen leave, which is much, much earlier. And so I think that that's where we would like to see this go versus, again, worst case scenario, what's laid out here potentially is a very long timeline.
Yeah, I just think that worst case scenario that it feels like it's unlikely, but I appreciate that. Thank you for your.
And then the last comment and.
Nope,
Thank
nope,
you.
nope,
Yes,
we
sir.
got the answer.
Mr. Chair.
Okay, next we will go to the virtual witnesses. There are 4. We'll start with those in favor. Sarah Coley.
Good afternoon, Mr. Chairman and members of the committee. My name is Sarah Coley, and I am an assistant counsel for Shelter Point Life Insurance Company. I'm here on behalf of both Shelter Point and as a member of the Maryland League of Life and Health Insurers in support of HB 988. And I would publicly like to thank Delegate Chi for sponsoring this legislation. Shelter Point is New York's largest provider of statutory short-term disability, covering almost 200,000 employers, most of which are quite small, with less than 10 employees. We provide this important coverage to nearly 2 million employees, and we have also been an approved private plan carrier for New Jersey state disability since 2003. Most recently, we began providing Massachusetts paid family and medical leave starting in 2021, and Connecticut paid family and medical leave starting in 2022, and have been approved to participate in both the new paid family and leave medical programs in Oregon and Colorado. We come with a history of experience in the statutory benefits field, which has been a resource in other states, such as Colorado, as they stand up their own family insurance program. Shelter Point, along with many other members of the league, stand ready to offer paid family leave policies in Maryland. Many private insurers are well equipped to provide these important employee benefits as they have the capital, organizational structure, and professional staff with expertise to handle benefits, including paid family and medical leave. We are an important resource, and our participation in the program has been demonstrated in other states to help make the paid family medical leave programs a success. Shelter Point, both as members of trade associations and on our own accord, have worked closely with regulators as PFML programs have been successfully implemented in Massachusetts, Connecticut, Oregon, and Colorado. And we look forward to continuing this close collaboration with the Maryland Department of Labor and the Maryland Department of Insurance to ensure that the paid family medical leave policies are available to Marylander employers. I respectfully ask that the committee favorably report this bill, and thank you again for your time. And
Thank you, ma'am. Next, we will go to Molly Williamson.
Thank you. My name is Molly Weston Williamson, and I'm a senior fellow at the Center for American Progress. I've been working on paid leave around the country for many years, and I'm especially proud to have been working in support of paid leave in Maryland since 2017. I want to thank the committee and the sponsor for the opportunity to speak. I'm proud to support this bill, which would clarify and improve the already strong Maryland law. In particular, I want to highlight that splitting the contributions 50-50 between employers and employees would be in line with established best practices, as we've seen from the trend in existing states, as well as with the shared rewards paid leave brings to employees and employers. As we've seen in state after state, once paid leave programs go into effect, employers win. Employers win in terms of increased productivity. They win in terms of improvements on recruiting and the ability to compete for the best employees. They win in terms of higher retention, which reduces costly turnover, benefiting the bottom line. And they win in terms of a lot of these fears that folks worry about don't really manifest. So we've seen in state after state that once programs are in effect, a majority of employers support the program. And I look forward to working with the state to see Maryland employers see those same benefits, which are a big part of why it makes sense that Maryland employers who will also benefit are helping to support the program. As some folks have already mentioned, last year, Maryland made the decision to exempt employers with fewer than 15 employees from paying into the system. And what a number of states have done with this approach is essentially the fund as a whole absorbs the additional cost. So it's not like the way that the current law lays out for home health providers or for employees with that make less than $15 an hour. So instead of the state picks up the tab, it's basically everybody pays a tiny bit more to offset those costs in the same way that the fund is picking up the administrative costs. As outlined in my written testimony, paid leave is a smart investment in workers, businesses, and the state's economy. I support this bill and I'm happy to answer any questions.
Thank you, Ms. Williamson. Quick question for you. Do you know how many other states do the 50-50 split? You had mentioned it.
Yes, and there's also there's a table about this in my written testimony. So
I can pull it up.
Of the 12 programs, 6 have a shared employer-employee cost. There's some outliers, like DC makes employers pay for everything. But of the 6 where it's a shared cost, 50-50 is the most common ratio. It's in Colorado, it's in Delaware, it's in Massachusetts. In New Jersey, employers pay a little bit more than 50-50. In Oregon, employees pay a little bit more than 50-50. So it's all kind of in that range.
Right, and then in like California, it's 100% employee, correct?
That's right.
Okay, all right. Seeing no additional questions, that concludes the virtual favorable. Next, we will go to favorable with amendments. Brianna, January.
Good afternoon, Mr. Vice Chair, honorable committee members. Brianna January with the Maryland Association of Counties. Committee, as you've heard, counties stand united with our partners in local government, the municipalities, and the local boards of education in supporting HB 988 with amendments. I thank the department for bringing forward critical amendments around the timeline and regulations, which counties strongly support. Like my colleagues from MML and MABE, I do want to stress the need to specify in the department's amendments that the department will publish clear and comprehensive guidance on the private plan equal benefit opt-out process as part of that January 1, 2024 deadline around regulations. I cannot stress enough how critical this is for all 24 counties as each considers its best option to meet the unique needs and capabilities of its jurisdiction. And committee, in response to some members' questions to my colleagues, I would like to state that counties too would absolutely support any effort of the committee offering a local government opt-out. We surely agree that it would be appropriate and in line with similar paid leave laws in other states, and of course is within the committee's jurisdiction to do so. With that, we look forward to working with you to make those changes, and we urge a favorable report with those amendments. Thank you.
Thank you. Seeing no questions, we will go to our last witness on this bill. He is unfavorable, Paul Frey. Mr. Frey, go ahead and begin when ready.
Good afternoon, Mr. Vice Chair, members of the committee. For the record, Paul Frey, President and CEO, Washington County Chamber of Commerce, representing 650 member organizations with over 40,000 employees, and respectfully testify in opposition to House Bill 988 as written. Give my written testimony outlining our concerns with the legislation as it's currently written, along with a number of suggested amendments that address our concerns. I'd like to thank a number of the committee members that oppose this legislation. We agree. However, given our numbers, we're working to make House Bill 988 more palatable to our members. Our small businesses in particular are struggling to understand the program, including how to implement and manage the program. And this includes those businesses with fewer than 15 employees that don't have to contribute to the fund. They still must collect contributions and then administer the program. We are requesting that this committee follow the suggestions provided by NFIB and the Maryland Chamber of Commerce on simplifying as much as possible this legislation, as well as delaying the program's implementation dates. Again, as written, the Washington County Chamber of Commerce respectfully asks for an unfavorable report on House Bill 988 as written. Thank you.
Thank you, sir. Seeing no questions, that concludes this panel and the bill hearings for today. I want to thank everybody, and I will see you all tomorrow on the floor.